What if it were illegal to hit the F12 key? And by illegal, I mean criminal penalties, fine and imprisonment. Moreover, what if most of the extensions you're probably running were illegal criminally? That is what is at stake in Yout v. RIAA. Regular viewers have heard me talk about this before. This is where you have software like YouTube DL, which allows you to download YouTube videos for which there are numerous legitimate and perfectly legal reasons why you'd want to do that. But according to a district court, you are violating criminal law and there is no fair use defense. So we're not going to go over the district court that much because there's not much to go over. We're mostly looking at their appeal to the Second Circuit, but we got to start at the beginning. And by the beginning, I mean the end of the district court case because it was just thrown out. And so what happened here is you can see Yout LLC, and they made a website that allows you to download YouTube videos, filed this 4-count suit against the RIAA seeking a declaratory judgment. And what that is you're not being sued for infringement, but because of various reasons, either there's a chilling effect or just so much uncertainty about what's going on, you just say, I want to go ahead and go to court and have this litigated. And so that's what you do. You go and you seek a declaratory judgment. You say, Judge, we want you to say our software is fine. We want you to say it's legal. We want you to say that Yout's software, which allows users to download audio, video, and audio-video files from major streaming websites, does not violate Section 1201 of the DMCA. The RIAA moved to dismiss the complaint for failure to state a claim, primarily arguing that the facts pled by Yout established that the software at issue circumvents an effective technological measure in violation of Section 1201 as a matter of law. And this is the same thing they've been trying to do for 25 years. This goes all the way back to Universal v. Corley, and all the way back to Universal v. Ramirez, and all of those other freedom-hating, anti-free speech, anti-fair use cases that so many activists have been trying to fight for so long. And what happened was the judge granted the RIAA's motion to dismiss and basically ruled improperly that Yout and YouTube DL and all these others were illegal. So all of this is really going to come together into the appeal. So this video is going to be in 3 parts. We're going to see what Yout has to say, and we're also going to see what GitHub has to say about the potential consequences of this, which are major. In the second one, we're going to see what the other side has to say. And then the third part will be really important. It's Amicus briefs in defense of Yout, and in particular tied in to the anti-AI cases that are going on right now. So let's look at what the district court said. This was 3 years ago, September of 22. On page 4, he wrote, using the Chrome browser's Developer Tools menu, the user may identify the largest file on the YouTube player page, which the second amended complaint implies is the downloadable video file. If the user copies and pastes the request URL for the video file into a new browser window or tab, then modifies the sequence to begin at 0, then a full-size video without sound will appear. In addition to the video, a 3-dot menu with the download option will also appear. The user may also download the audio file by doing the same thing. As a result, the user may download separately a video file and an audio file. And then you just use something like FFmpeg to mux them together and you got your video file. Now, what he said on page 5 is important. This is critical, and it's amazing that he spends the rest of the ruling going against it. He says, the mechanism used by Yout's platform does not require any password, key, or other secret knowledge to access a YouTube video. Rather, YouTube provides the means of accessing its video to anyone who requests them. In other words, you already have access to the video. And this is going to be important, as we'll see the DMCA works differently when it's an access protection rather than when it's a mere copy protection. And you can see it yourself over on 13. For its part, the RIAA counters that YouTube has a technological measure because, inter alia, there is no download button or other feature on a YouTube watch page that allows users to copy the underlying files. So because they didn't give you a little download button, that means it's illegal to get it. that consumers would not need Yout if YouTube's files were freely accessible, even though they are, and that Yout's convoluted step-by-step instructions rebut its claim of freely given access. But what does it matter how convoluted it is? Ultimately, what you're doing is making an ordinary HTTP GET request, and YouTube just sends it to you. There's no access control in the way. You got to go through a little bit to get that URL, but how convoluted it might be doesn't have anything to do with it, and suggests that in the ordinary course, an ordinary YouTube user does not engage in the enumerated procedure. So, as far as I'm concerned, the RIAA just framed it perfectly. Any reasonable person can read the RIAA's own words and see how ridiculous their claim is and how ridiculous this judgment is. Everyone except Judge Underhill, that is. I conclude there is enough information in the second amended complaint to answer the threshold question of whether YouTube has a technological measure in the affirmative, and to conclude that Yout does not plausibly plead that YouTube lacks a technological measure within the meaning of Section 1201A. It is self-evident from the screenshot that YouTube does not readily offer a download button or another feature by which the user may access a downloadable audio or video file. YouTube then restrains its users' access to audio, video, and audio-video files by directing users to stream, not download audio and video. But that has nothing to do with access. Most users don't want to because they don't want to have to wait to download the entire file before they watch. Maybe they're watching on a device that doesn't have that much space or have that much memory, so they only play just a little bit of the video at a time. And as they're watching, they're downloading more chunks ahead while they're discarding chunks left behind. That's how streaming works. That doesn't mean you don't have access to it. You do have access to it. YouTube directs users to stream videos and, by not making a download option readily available on the player page, restrains users' ability to access and copy audio and video files. Indeed, from Yout's own allegations, YouTube appears to altogether prevent users from accessing and copying AV files. Well, then they don't do a very good job of it, do they? Moreover, initiating a stream requires a browser to read and interpret the signature mechanism and to derive a signature value. I really wish they'd stop calling it a signature. It's not a signature. It's not in any way a signature. It's a sequential number. It's not a signature. Unleashing access to the downloadable audio or video files requires modifying the range sequence, which I infer is the signature value without which there is no stream. If you've seen my coverage of this before, you know all you have to do is delete that variable and you get the whole thing. Without modifying the signature value, there is no access to the downloadable file. Yeah, but take it out and there is. Because Yout alleges that the download option only appears in the post-modification player window and will not work without modifying the range value, I infer from the allegations that the signature value must constitute an access control. Oh my God. Yes, this is that bang your head on the table stupid. Because he said earlier clearly why it is not in any way an access control. And now it's an access control just because you have to delete a little section when you copy the URL. It's dumb. So Yout appealed to the Second Circuit, and thus begins our story in earnest. This is a long one. It's a 92-pager. It's actually not all 92 pages because there are exhibits and everything. But we are going to skip through and start at the bottom of page 39 of the PDF document, which is 32 on the labeled number on the bottom. The district court below clearly recognized the difference between the DMCA's access control and copy control provisions. Because a copyright owner's rights include an exclusive right to reproduce a copyrighted work and to distribute copies by sale or otherwise, 17 U.S.C. Section 106, subsection 1201B is often deemed the copy control provision. Having properly articulated this distinction, however, the district court nonetheless proceeded to analyze the RIAA's arguments almost exclusively under 1201A, holding that Yout violates the access control provisions of the statute, even though it is inconceivable for any number of reasons that Yout does so. And the fact is, there is one overriding issue that should have prevented the district court from finding in the RIAA's favor, regardless of which provision the district court was considering. Each of the three relevant provisions requires, as a threshold matter, the existence of a technological measure protecting something, whether that something is the ability to access a copyrighted work or the protections afforded to that work under U.S. copyright law. The RIAA and the district court have both assumed the existence of such a technological measure, a factual question without any valid basis to do so. And keep in mind, the judge threw this out before there was any fact-finding at all. There was no discovery, there was no finding of fact, he just tossed it out. There is little question here that there is some bit of technology, a small bit of JavaScript code at play here. That code is the technology. There is no evidence, however, that YouTube intended this to be a technological measure designed to limit access or copying at all. And if the technology was not designed or intended to limit access or copying, the defendants cannot claim retroactively that such a technological measure exists by happenstance. And while it is true that it may not be an unreasonable assumption that YouTube intended this technology to be a technological measure, such an assumption is precisely the type of disputed fact that must be tested via factual discovery. YouTube is not a party here, and the defendants can no better speak to YouTube's intentions than Yout can. It is equally plausible that the JavaScript code has nothing to do with any interests the copyright holder might enjoy, and everything to do with YouTube's own interests. For example, YouTube compensates content creators who share their content on YouTube based on the popularity of the videos the content creators post. It is certainly plausible that the JavaScript code is designed to ensure that a content creator is not using an automated system to make it appear as if a human is accessing a video, when in reality the request is coming from a bot farm designed to increase the compensation paid to the content creator. Under that circumstance, the JavaScript code would have nothing to do with protection of any rights afforded to the copyright holder. This is not to say, of course, this is actually why YouTube utilizes the JavaScript code. Yout has no way of knowing at this stage of the proceedings the intended purpose of this bit of technology or why YouTube deploys it. By the same token, neither do the defendants. It might simply be because that's how they're making the streaming part work. The district court perplexingly counts the vast majority of its opinion in terms of a purported analysis under Section 1201A1, even though it is clear from the SAC and the parties' arguments below that the RIAA had alleged in its takedown notices to Google that Yout provided access to a service that the website's users could allegedly use to circumvent technological measures. This is a clear error of law. Specifically, the RIAA in its takedown notices to Google did not allege that Yout itself directly circumvened YouTube's technological measures, but rather the RIAA alleged that the Yout website provides access to a service that circumvents YouTube's rolling cipher. I hate that they call it a rolling cipher too. It's not rolling and it's not a cipher. All these are complete misnomers. A technological protection measure, that's a laugh, that protects our members' works on YouTube from unauthorized copying and downloading. As such, even if the Yout website provided a service that allowed visitors to the website to circumvent a technological measure that effectively controlled access to copyrighted works, which it most assuredly does not, Section 1201A1 would still be inapplicable because Yout provides access to a service and does not itself access the works, regardless of whether such access could be considered to be circumvention or not. Yout doesn't access a thing. The users of Yout do the accessing. Page 46, there is one area in which the courts, including this court and commentators, are unanimous. Section 1201A concerns itself exclusively with the question of access to copyrighted materials and not what happens to those materials once they are accessed. That's from Corley. Bottom of 48, in the present case, there is no question but that the works at issue are freely available. anyone with a computer and a web browser can go to youtube.com and access the works. Indeed, it is clear from YouTube's terms of service, which the district court took judicial notice of, that by providing their videos to YouTube, the defendants explicitly agreed that YouTube's visitors were permitted access to the works. Rights you grant, you retain ownership rights in your content. However, we do require you to grant certain rights to YouTube and other users of the service as described below, and they can access it and watch it and play it. This explicit grant of access permission by the content provider is fatal to the RIAA's arguments. 1201A3 defines the term circumvent a technological measure to mean to descramble a scrambled work, to decrypt an encrypted work, or otherwise avoid, bypass, remove, deactivate, or impair a technological measure without the authority of the copyright owner. The RIAA's arguments fail each part of this definition. Yout has plausibly alleged in the SAC that its software does none of the things defined as circumvention in this section. There's nothing to descramble or decrypt. Far from avoiding, bypassing, removing, deactivating, or impairing any technology employed by YouTube, Yout simply engages with YouTube's technology in precisely the manner that YouTube intends the public to engage. YouTube's server generates a small bit of JavaScript code that it intends the receiving computer to run in order to access the file. YouTube provides this to anyone desiring such access. There's no circumvention at all, merely the use of YouTube's technology in precisely the way YouTube intends. And, as YouTube's terms of service make clear, all of this is done with the explicit consent of the content providers. The SAC explicitly alleges that it does not circumvent YouTube's technology, citing to a letter from the EFF. Because the letter was key to Yout's assertions in the SAC, the district court took judicial notice of it. They explained YouTube DL simply uses the signature, they keep putting that in quotes, notice, code provided by YouTube in the same manner as any browser, rather than bypassing or avoiding it. Nevertheless, the RIAA contends that Yout's service circumvents a technological measure, despite the fact that Yout simply uses the process that YouTube makes available to anyone who wants it. This argument has been rejected by the courts. Because YouTube does not in any way restrict access to the works at issue, the district court erred in finding, as a matter of law, that Yout violated the anti-circumvention access control provisions of the DMCA. The district court then purported to fashion its own definition for the term controls access, and in doing so, managed to obliterate entirely the distinctions between access controls and copy controls by finding that the term controls access was expansive enough to include a technological measure designed to prohibit the download, i.e. copying, of a particular video file. If they're doing it to prevent you from copying it, it's a copy control, not an access control, and you're looking at the wrong paragraph. Alright, let's skip ahead to the top of page 65. Any individual using a web browser can simply view a web page's source code using the built-in developer's tools, identify the URL, and use that URL to directly download the component parts of the video using common software to put those parts back together again. This is not, as the RIAA argued below, an argument that YouTube's software fails to effectively protect the defendant's rights under copyright, if it is even intended to do so, because such protection can be easily thwarted. This is an argument that YouTube's software does not effectively protect the right at all. The RIAA has argued, however, that despite any person with a web browser having the ability to copy and download videos from YouTube using the developer's tools, and despite the existence of an untold number of websites that instruct people how to do precisely that, YouTube still employs a technical measure that effectively protects their rights because, in their view, most people will find the process of using the web browser's developer tools difficult or burdensome to undertake. Presumably, it is not easy to extract data from a memory chip in a printer and then reassemble that data into a program that might allow a person to use a competing toner cartridge with that printer. And yet, that did not prevent the Lexmark court from finding a lack of effective protection there. Ultimately, however, this becomes a question of fact for a jury to decide. Remember, that's all we're arguing here, whether this case can go forward or whether the judge can just arbitrarily go, no, RIAA wins, boom. The court cannot consider that question of whether there is a technological measure effectively protecting a right held by the copyright owner without considering if the copyright owner really has the right it asserts. Here it has long been established that an individual may legally make fair use of a copyrighted work by making a copy of that work so as to time shift or location shift the viewing of the work. That was way back in Sony v. Universal, where they said, yeah, you can record something off the TV and watch it later. Although the district court recognized Sony as well-settled anti-infringement law, it brushed aside any consideration of Sony in a footnote. A technological measure cannot be said to be effectively protecting a right held by a copyright owner if the right being protected is not a right at all. Just bear with me, we're getting to the end and then we'll get to what GitHub has to say. It is important to remember that in enacting the DMCA, Congress was concerned that these sections might be misinterpreted to include devices or services that had significant non-infringing uses. Indeed, the legislative history is emphatic that Congress did not intend this section to include devices with multiple uses such as VCRs. Yout has alleged in the SAC that it has significant commercial uses other than to circumvent protections afforded by a technological measure that effectively protects the rights of a copyright holder. Indeed, one has to do little more than consider the fact that the majority of video files available on YouTube are not music videos, and they are not necessarily protected by any copyright. Yeah, what about videos in the Creative Commons like all of mine? Just download it, take it, remix it, pass it on. Indeed, the software on which Yout operates has been widely recognized to have many legitimate uses, including for journalists, historians, and political activists around the world. So, for the reasons stated here and above, the court should reverse the district court's judgment dismissing Yout's complaint and remand for further proceedings consistent with such reversal, which means going on to discovery, going on to a trial, and so on. So basically a week later, GitHub submitted an amicus brief in support of neither party. They were just giving information, in which they say, starting at the bottom of page 8, GitHub takes no position on the ultimate resolution of this appeal on the facts pled by Yout, but the district court's expansive interpretation of the DMCA's anti-circumvention provision compels GitHub to point out how the court's rationale needlessly threatens countless other software tools in widespread use. Developers routinely design software that allows users to experience content in new and value-enhancing ways without express permission from a copyright owner. By interpreting the DMCA in a way that conflates measures controlling access to a work with measures controlling use of a work that is already publicly accessible, the district court's ruling threatens to imperil the software developers who create those tools, ensnaring legitimate software within the DMCA's reach and chilling technological innovation. The court should reject the district court's flawed interpretation. Bottom of page 12, the court nowhere disputed that the videos consumers access through Yout's website are the same ones they can access directly through YouTube's own interface. In other words, the same works. They found a DMCA violation merely because Yout allows users to experience those works differently from how an ordinary user in the ordinary course experiences them on YouTube, by downloading rather than streaming. YouTube's decision not to provide its own download button, however, is not a restriction on access to works. It merely affects how users experience them. The district court's expansive interpretation is particularly alarming because, unlike most copyright provisions, the DMCA imposes criminal penalties. There's fines and imprisonment at stake here. Up to $500,000 and 5 years in prison for the first offense. That's what we're talking about. Those penalties require that ambiguities in the statute be resolved in favor of a narrower construction. At a minimum, those penalties underscore the importance of rejecting a construction that sweeps in a broad range of widely acceptable conduct. Because even if you've never hit the F12 key once in your life, a lot of the browser extensions you are running right now might be criminal under this interpretation, because they affect how users experience web pages by changing the way the pages appear. Many of these extensions are wildly popular and used by millions of people worldwide, but the district court's reasoning threatens even the most innocuous and widely adopted examples. Dark Reader, for example, use it all the time, is an open source eye care browser extension with more than 5 million users. It automatically replaces a website's color scheme with an alternative scheme less straining on the eyes, substituting, for example, white on black text for black on white. The New York Times website, for example, does not have its own dark mode button because they suck. Yet, Dark Reader enables consumers to view the website in dark mode nonetheless. On the district court's flawed reasoning, Dark Reader would be circumventing the publisher's website design decision not to include its own dark mode. The Google Translate browser extension, with over 10 million users, allows viewers to translate web pages into other languages. The Open Dyslexic extension replaces web page fonts with a specialized font more easily read by people with dyslexia. The Print Friendly extension rearranges web page layouts to make them print better. None of these extensions circumvent restrictions on access to content, but they all enable users to experience the same content loaded from the same place in a manner different from how an ordinary user experiences the content. Screen readers are another example, making it easier for individuals with disabilities to experience web content. Screen readers enable those who cannot see the screen to access information on computers and smartphones. Conversely, other technologies convert audio to written text, enabling people with hearing disabilities to understand spoken dialogue by automatically generating captions. If you doubt this is a problem with the DMCA, look up the name Dmitry Sklerov. He committed the crime of writing software that allows the text in a PDF file to be run through a text-to-speech algorithm so that deaf people can hear the text read out. He went to Las Vegas, I believe it was for DEF CON, gave a talk that wasn't related, but as soon as he finished the talk, he was arrested! Arrested for making it possible for deaf people to hear text in a PDF file read out. It actually happened! Look it up, Dmitry Sklerov. How can you possibly defend that? Screen readers and automated captioning programs only provide access to work a publisher has chosen to make accessible, but under the district court's flawed theory, they too could be circumventing access controls by enabling users to experience content in a manner different from how an ordinary user does. What about ad blockers? Ad blocker browser extensions that disable those annoying pop-up ads, as well as the cookies that advertisers use to track users on the internet. Those ad blockers benefit users in several ways. They not only eliminate distracting interruptions from web pages, but also enhance user privacy by preventing tracking and improve security by removing a well-known point of vulnerability for malware. Ad blockers do not enable consumers to access any content the publisher has not already chosen to make available, but by stripping out ads, they permit consumers to view publicly accessible content in a manner different from how a consumer ordinarily does. On the district court's erroneous theory, the developers who offer those widely embraced applications could be criminals facing hundreds of thousands of dollars in fine or years in prison. And there have been several attempts to try and make ad blockers illegal. With this, they could succeed. Custom media players. YouTube's own interface permits users to play, pause, and scroll through videos, but third-party applications give them more flexibility. VLC Media Player, for example, open source, enables users to stream YouTube videos by entering the video's URL address into the application. The user can then access a rich set of playback features not available through YouTube's native interface, such as fine-grained control over playback speed and filters that modify contrast or brightness. Archiving, tools that download content displays on web pages, are also critical to many web services consumers take for granted. Search engines collect information, distill the vast expanse of information on the internet. They're trying to make scraping illegal too, remember? The Internet Archive's Wayback Machine is another example. Website publishers who display information on their web pages do not typically invite users to download pages. Indeed, some web pages affirmatively try to disable user copying. Under the district court's flawed analysis, services that nonetheless sought to archive those materials would be violating federal law. The district court's rationale thus imperils wide swaths of conduct that the software development community considers both acceptable and desirable. The court should not interpret the DMCA and its harsh criminal penalties in a way that threatens those beneficial activities. Right on. And that's where we need to stop for this video, but those of you who are going to accuse me of being one-sided, the next video is going to be the other side. We're going to hear from the RIAA, and we're also going to see an Amicus brief from the Copyright Alliance. We'll hear what they have to say, and then after that, part 3 of this will be Yout's reply, and then the Amicus from Suno and Udio, which is really important here, so please stick around for that. The best way is to hit the subscribe button and the bell, so you'll be sure to be notified of these. And of course, do the other algorithm stuff, leave a comment, and share. Sharing does more than you know. Sharing gives it a bump in the algorithm and lets it be seen by even more people before the shadow banning kicks back in again. And if you really want to help, donate.bogosity.tv gives you several ways to do so, one-time payments or regular support, where you can get benefits like getting these videos early and ad-free. Thank you so very much for watching. We'll see you for part 2. Until then, stay strong and be free.